Welcome to the Regulatory Policy Seminar. I'm Joe Aldi, the Faculty Chair of the Regulatory Policy Program at the Mosavar Rahmani Center for Business and Government at the Harvard Kennedy School. Let me open with a few reminders regarding the logistics of our online seminar. We are recording this seminar and posting it online. So if you know of someone who is interested but cannot attend the talk live, please let them know that they can access the seminar at the Mosavar Rahmani Center for Business and Government's YouTube channel. And I'll post the link for that in our chat in just a moment. You can also remind friends and colleagues to register for Zoom links for each seminar at the RPP webpage. And we'll include a link for you in the chat in a moment as well. We will take questions today through the Q&A function in Zoom. Please click on Q&A at the bottom of your screen and type your questions. At the end of the presentation, I'll take the questions and pose them to our speaker. We're excited to have Amy Sinden join us in the Regulatory Policy Seminar to present Regulatory Review Progressive Style, Suggestions for the Biden-Harris Administration. Professor Sinden is a professor of law at the Temple University Beasely School of Law and on the board of directors of the Center for Progressive Reform. She writes and teaches in the areas of environmental, climate, and natural resources law. She's written about the misuse of economic theory and environmental law and about the application of classical human rights norms to climate change and other environmental conflicts. Before joining the Temple faculty in 2001, she practiced law for 10 years, including representing citizens groups in Clean Water Act and endangered species litigation with Earth Justice and Penn Future. Amy, welcome to the Regulatory Policy Seminar.
Joe, thank you so much for having me. I'm really delighted to be here. I wish I could be here actually in person in Boston with y'all, but instead I am reporting from my daughter's bedroom here in Philadelphia. She's in school, so she won't be joining us, as she sometimes does. Our system of centralized regulatory review and its primary tool, cost-benefit analysis, dates back to the Reagan administration. And it's rooted in a political narrative first popularized by Reagan, but that really took hold and dominated our public policy for the next 4 decades. This is the story that says regulation is an unmitigated bad. It's red tape. It's a job killer. And that regulation is something that needs to be reined in, cut back, and defanged. But today, the world and the political landscape that the Biden administration has inherited has shifted radically. In the face of a raging pandemic, increasingly urgent calls for racial justice, a widening wealth gap, and an accelerating climate crisis, that anti-government, anti-regulation narrative has lost a lot of its salience. It's become pretty clear to a lot of people that government regulation is the only thing that's going to keep us safe from disease, address racial and economic inequality, and stave off climate apocalypse. And the Biden administration, I think, really gets that. In its executive order on modernizing regulatory review, this was one of the ones that Biden signed his very first day in office. He made clear that he's rejecting that old narrative of regulation as red tape or a job killer. I mean, just look at some of the language in this executive order. Regulations that promote the public interest are vital for tackling national priorities, he says. And instead of talking about relieving burdens on industry, Biden's executive order talks about revamping regulatory review to ensure that it does not have harmful anti-regulatory or deregulatory effects. That is really a radical shift in perspective, and not just from previous Republican administrations, but from prior Democratic administrations as well. I think the Biden team really gets that in this current landscape, we need an entirely different vision of regulation and of regulatory review. One that's up to meeting the challenges of the day. And it's in that spirit, I think, that this executive order directs OMB to begin a process to produce a set of recommendations to improve and modernize regulatory review. And that, of course, is what I want to talk to you about today, or some ideas that I have about how they may want to go about doing that. But before I get to that, I want to back up a little bit and talk about how our current system of centralized regulatory review originated, how it's evolved over the past 40 years, and what's wrong with it. Then, with that foundation in place, I'll talk about some ways in which I think the Biden administration will want to reform the process if its ambitious public policy agenda is going to succeed. So our story starts in the late 1970s. Now, in the early part of that decade, the country had just witnessed an explosion of federal legislation on air pollution, water pollution, endangered species, hazardous waste, worker safety, consumer protection, and so on and so forth. Industry was really, for the first time, being held accountable for the various public harms resulting from their activities, and they didn't like it. They were looking for some tool that would help them push back against all of these new rules coming out of federal agencies that were costing them money. And they found that tool in an idea that had been percolating for a decade or two among a set of conservative economists at the University of Virginia, University of Chicago, London School of Economics. The idea was that rather than just assuming that government should step in and regulate anytime the free market produces an externality, you should instead put the burden on government to prove before they issue a regulation that it's going to produce the same results that a theoretical, perfectly functioning free market would produce. That is, that it would maximize net social benefit. This would essentially require the government agencies to conduct a grand cost-benefit analysis of all the social costs and benefits of a regulation before they could issue it. So industry and their political allies on the right latched onto this idea and tried to get it incorporated into law. They figured, at a minimum, it would bollocks the agencies up and delay things. And then would also tend to make regulation weaker by overemphasizing regulatory costs, which would be relatively easy to quantify, while underemphasizing the benefits, which are far harder to quantify. Initially, their attempts weren't very successful. Congress rejected the idea in virtually every one of the statutes they passed in the 1970s. Instead, they directed the agencies to set standards for clean air, clean water, safe workplaces, and so on at the level necessary to protect the public health, or based on something called a feasibility standard, which essentially says, reduce pollution levels as much as you possibly can within the limits of technological and economic feasibility. And the courts generally read the statute as written and rejected industry arguments that they should be read to impose a cost-benefit standard. But then in 1981, industry found a friendly ear in the newly inaugurated President Reagan. So even though most of the statutes, as I said, directed the agencies to set standards using a fundamentally different framework, they got Reagan to sign this executive order that imposed a requirement on agencies that they conduct a cost-benefit analysis of all major regulations. This created a sort of administrative overlay on the existing statutory process. And it led to this crazy anomalous situation we have today, whereby an agency might actually be prohibited by the statute from basing its regulation on a cost-benefit analysis, but then be required by the executive order to do a cost-benefit analysis that it then has to pretend not to consider. The Clean Air Act's national ambient air quality standards, which the Supreme Court confirmed EPA has to set without reference to cost, for example, is a case in point. So Reagan's order remained in place until 1993, when Clinton replaced it with Executive Order 12866, which remains in effect today. And with this order, Clinton really tried to implement a sort of course correction from the Reagan-Bush years. His order emphasizes the importance of unquantifiable variables, the imperative to consider distributional impacts and equity, and the primacy of federal agencies and their mandates in regulatory decision-making. But the progressive and high-minded language in that executive order wasn't enough to overcome an entrenched agency culture at OIRA. The reality is there's a lot of different ways to rationally analyze the costs and benefits of a regulation. But over the years, OIRA has drifted away from the progressive vision of 12866 and instead congealed on this highly formalistic version of cost-benefit analysis grounded in the paradigm of Kaldor-Hicks efficiency. This kind of analysis involves a comprehensive, quantified accounting of all costs and all benefits to society as a whole, and it emphasizes the calculation of net benefits in order to identify the alternative that maximizes overall social welfare. So what's wrong with this formal version of cost-benefit analysis? There's basically two problems I want to talk to you about today. The first one is that cost-benefit analysis is inherently and fundamentally incapable of examining issues of fairness, justice, and distributional equity. In fact, obscuring these issues is really built into the design of cost-benefit analysis because it measures social welfare in the aggregate, right? So if Jeff Bezos has 99% of the wealth and the rest of us are all fighting over the remaining crumbs, that's not going to be apparent from a cost-benefit analysis. And it's not even like the data that you collect for cost-benefit analysis is in most instances going to be useful to you if you're trying to look at distributional impacts. So because of this, cost-benefit analysis is simply not the right tool for this historical moment, because it's tone deaf to the racial and economic justice issues that are literally tearing this country apart right now. And then the second thing is that this formal brand of cost-benefit analysis assumes a world in which all or nearly all relevant values can be quantified and expressed in monetary terms. But that's just not true. In the real world, when it comes to regulatory benefits like public health and safety, ecosystems, economic well-being, we just don't have anywhere near sufficient data to undertake that kind of precise accounting. We know that various forms of pollution or unsafe working conditions, consumer products, or risky financial practices are causing harm, and that curtailing them will prevent harm. We just can't say precisely how much. The EPA actually provides a really good example for this because it's often held up as one of the agencies where the practice of cost-benefit analysis is the most advanced and sophisticated. So 2 years ago, I completed an empirical study that looked at the major EPA rulemakings over a 13-year period spanning the George W. Bush and Obama administrations. And this study found that in 80% of its cost-benefit analyses, the EPA was unable to quantify whole categories of benefits that the agency itself described as either important, significant, or substantial. The fact is that of the dozens of pollutants that EPA regulates, there's really only one particulate matter, for which the EPA has extensive data. There's a whole set of reasons why particulate matter has been much easier to study than the others, but the result is that for the vast majority of the benefits that EPA is able to monetize for all of its regulations as a whole, or 94% in my data set, are attributable to this one pollutant, particulate matter. For most of the other pollutants, they're simply unable to quantify any of the impacts. And even the relatively big numbers that the agency generates on particulate matter are actually far from complete. They leave out cancer and other long-term effects that are associated with human exposure, but a lot trickier to measure. The problem is so severe that in many instances, the EPA is entirely unable to quantify the impacts associated with the pollutants that the regulation is actually aimed at controlling. So in most of EPA's hazardous air pollutant regulations, for example, 100% of the agency's monetized benefit estimate is attributable instead to the fact that the rule also has the ancillary effect of reducing particulate matter emissions. Now, this is perfectly legitimate as a matter of economic theory, but the EPA's heavy reliance on these co-benefits, as they're called, has really landed the agency in some political hot water, as the right wing has latched onto this practice as a sign that the agency is resorting to subterfuge to skew its cost-benefit analyses by inflating its benefit numbers. In all of these instances that I'm talking about, the lack of quantification stems from inadequacies in the data. But that's to say nothing of the many values that resist quantification altogether, but nonetheless arise with some frequency in regulatory decision-making. Things like protecting the dignity of people using wheelchairs, or reducing incidents of rape in prison, or reducing the occurrence of back-over crashes in which parents accidentally kill their own children. Benefits that can't be meaningfully quantified represent a significant and pervasive problem that makes the hyper-formalistic variety of cost-benefit analysis that now dominates agency practice unworkable much of the time. The point of a highly formalized cost-benefit analysis and the source of its purported advantage over other decision-making tools is its theoretical ability to identify the economically efficient, i.e. welfare maximizing level of regulation. But where significant benefits can't be reliably quantified and monetized, net benefits can't be meaningfully calculated. And that means identifying the alternative that maximizes net benefits is therefore impossible. In such circumstances, actually, in the words of OIRA itself, cost-benefit analysis is less useful and can even be misleading. But nonetheless, despite these yawning data gaps, agencies feel enormous pressure to monetize both sides of the equation and hesitate to submit rules unless they can make their case on the numbers alone. And making that case is made even more difficult by the practice of applying high discount rates that have the effect of drastically shrinking the benefits that will accrue to future generations, sometimes down to almost nothing. The result is to impose on agencies an often insurmountable burden of proof, putting a chilling effect on the implementation of regulatory safeguards and leading agencies astray from their statutory missions. This flies in the face of the precautionary principle, the idea that we should prevent harm before it happens, even if that requires acting before all the data are in. So what's the solution? I think the most important thing to recognize here is that there are other ways besides this hyper-formal cost-benefit analysis practiced by OIRA to rationally analyze regulatory decision-making and to consider costs and benefits. In fact, as I mentioned earlier, virtually all of our health, safety, and environmental statutes directed agencies to use one of these other methods. One of the most prevalent methods, for example, is often referred to as feasibility analysis. But the way feasibility analysis actually operates in particular statutory contexts, I think it's really best thought of as one component of what can be called a sequential cost-benefit analysis. Statutes that take this approach usually direct the agency first to make a threshold finding, usually non-quantified, that the pollutant or other hazarded issue is harmful, such that there will be some significant benefit from regulation. It then makes a more granular examination of the technologies available for reducing the pollution levels, their costs, and the financial capabilities of the industry, using this information to set a standard, the most stringent level that's economically and technologically feasible. Like cost-benefit analysis, this approach ensures that the costs and benefits of a rule are accounted for and that some check exists for keeping benefits appropriately balanced against costs. Its method for striking this balance, however, reflects Congress's judgment that we should base regulatory decision-making on the information we have rather than on the information we wish we had. And that reducing significant risks as much as feasible will ultimately serve the public interest better than a quixotic attempt to produce a comprehensive accounting of social costs and benefits. Feasibility standards have a strong track record in US law. They're credited with bringing about dramatic improvements in air and water quality during the last 4 decades. And their ability to produce on-the-ground results, I think, is attributable in large part to the feasibility principles recognition of existing data gaps and its ability to work within them. Now, there are other well-established decision-making tools for considering costs and benefits as well, including cost-effectiveness analysis, a qualitative Ben Franklin cost-benefit analysis, multi-factor qualitative balancing, and for situations where outcomes are really unclear, a method that's actually been practiced by the military for decades, scenario analysis. Recognizing that formal cost-benefit analysis is fundamentally incompatible with attention to questions of distributional equity, that pervasive data gaps make it unworkable in many contexts, and that there's no one-size-fits-all tool for regulatory decision-making. I think OMB's new modernized system of regulatory review should direct the agencies to use the context-specific methods that Congress called for in their organic statutes for considering costs and benefits. This new order, the Biden administration should also implement a set of specific practices aimed at elevating unquantified benefits to the same level of attention and consideration that's accorded to quantified effects, and also aim to bring distributional impacts front and center, including consideration of cumulative burdens in frontline communities. Now, I have this last slide here is some more specific proposals for the Biden administration along those lines. But I think I'm going to stop here because I've sort of talked at you all long enough, and see if you have questions.
Great. Thank you, Amy. Let me remind everybody that you can use the Q&A button at the bottom of the Zoom window to submit your questions. I have a few questions and I've received a few from colleagues via email. One question for you, Amy, just in terms of the logistics of the seminar. Do you want to keep this slide up or should we take this slide down?
Take it down. We can just go to regular mode.
Okay. So let me start with what I think is kind of a big picture question about how we think about what role the current regime has played, as you noted through the history dating back to the Reagan administration, the role of conducting benefit cost analysis was played in regulations. And it'd be useful to sort of tease out from this where we think regulatory policy has been affected and been directed one way or another by the status quo, and how it would be different under this proposed alternative that you discussed at the end of your talk. Because as you noted, regulatory agencies in a sense have two bosses. They have Congress, which gives them the statutory authority. They've established objectives. You noted in a number of these environmental statutes, there's not any kind of weighing of benefits and cost in driving or in authorizing agencies on how to pursue regulatory action. And then there's the White House in one form or another, dating back to 1981, saying we want to see some kind of weighing of benefits and costs, whether it's a really strict benefit cost standard, like in the original Reagan executive order, the one that was a little bit more nuanced of benefits needing to justify costs, and some language about why there are some perhaps non-quantified or non-monetized categories of benefits could be used to justify cost. That's in the Clinton executive order. But it'd be helpful to get a sense of where we think regulatory policy is different today because of regulatory review, how it's different. Is it different in the ambition? Is it different in the way we've structured regulatory approaches? And how might we see things evolve if the Biden administration adopts this sequential approach that you described?
Mm-hmm. Yeah, well, I mean, there's certainly examples of OIRA review resulting in actual weakening and certainly delay, both weakening and delay of regulatory safeguards. Now, some of this is sometimes hard to piece together because there's been such a problem with transparency at OIRA, and I think this is another thing that the Biden administration is at least talking about trying to improve, which would be all to the good. So sometimes it's a little hard to see exactly what's going on, but they have, for a number of years, had to release redlined copies of the regulation before and after, so you can get a sense. And so, for example, I did a case study of the cooling water intake rule for big power plants, which was a big deal. I don't know, gosh, I guess that was 10 or 15 years ago now. But that's one where you could see a very clear weakening of the regulatory protections put in place by that rule as a result of the OIRA review that stemmed basically from the difficulty that EPA was having in quantifying the benefits there. And you know, by the way, water, I was talking primarily about clean air regulations with EPA. That's the place where they're the best at quantification. When it comes to water, it's a mess. I mean, it's really hard because there you're talking primarily about ecological harms that are even less studied and less well understood and more difficult to quantify than harms to human health. So that's one example, but there's the other thing that's really important is that based on what we hear from people who have spent time within the administration. So for example, if you look actually both at Cass Sunstein's writings and Lisa Heinzerling's writings, after they spent time in the Obama administration, right? Sunstein as OIRA director and Heinzerling was in the corresponding office at EPA that was interfacing with OIRA. Ironically, because Heinzerling used to be like a protege of Sunstein, so it was a funny thing. But what you get the distinct impression from them that there's a sort of chilling effect of the cost benefit requirement. And that comes, you know, and you're absolutely right that the Clinton order that is still in effect today really tried to soften the edges of the Reagan order, as I said. And one of the important things it did is it changed that word outweigh to justify, which obviously allows, the idea there was to allow a little bit more wiggle room, and then talked repeatedly about unquantified benefits and the importance of considering them. The problem is that in practice, it doesn't work out that way. And I think, there's a lot of different ways you can try to explain that. Some of it maybe comes from the sort of institutional culture at OIRA, where the staff are predominantly economists who have a sort of very quantified way of thinking. I think some of it comes from what has been called the cognitive lure of numbers and their tendency to sort of crowd out non-quantifiable variables and kind of bring all the attention on themselves, so that even when agencies try to talk in narrative terms about non-quantifiable variables, they inevitably kind of get left out in the kind of summaries and sound bites that get used to describe regulations. So because of a whole mix of forces like that, what's happened is that the agencies feel chilled and basically afraid to put forward a rule to OIRA unless they can show that the monetized benefits are going to exceed the monetized costs. And so what that means is there's a bunch of things that never even make it to OIRA review because of this sort of chilling effect that the entire process has had on the agencies.
Yeah, it's probably fair to say that applies under some statutory authorities and not others. Right? I mean, because, as you noted, the Supreme Court's ruled that in the context of the National Ambient Air Quality Standards at EPA, they can't actually take costs into consideration. And as we've seen some in the past, where environmental groups will take EPA to court if they are failing to meet a statutory deadline, and say a provision like the National Ambient Air Quality Standards, there is supposed to be a periodic review of those standards. It seems like that may be a case where it may not necessarily have the same chilling effect to one where there's perhaps more discretion on the timing and perhaps even of the form of a regulation that EPA may have. I mean, is that a fair assessment, that there's some cases where EPA's hands get tied when they realize they're behind schedule? Or we can think about this in other contexts, like Department of Energy has minimum efficiency standards for appliances. The law is very unambiguous. They're supposed to review them every 6 years. And in fact, one of the things happening that was on Steve Chu's plate on day one when he became Secretary of Energy was a consent decree, basically, or they were in the negotiations of a consent decree that was agreed to a couple months into the Obama administration, on how they were going to meet that statutory requirement to actually review and update those minimum efficiency standards, because the Bush administration had let that schedule lapse. So aren't there some cases where we've got both a clear understanding, especially say under the Clean Air Act, that we're not going to weigh benefits and costs, and we've got this kind of schedule that provides a hook coupled with the citizen supervision of the Clean Air Act that ensures that the regulations can still be brought forward, but there may be other regulatory contexts under other statutory provisions where that may be a chilling case? Or do we think this is a chilling effect throughout everything that's being done in the regulatory agenda?
Well, I completely take your point. I mean, and that's sort of part of my point, is to say there is no one size fits all tool. We have to look at this contextually, and that what works for one agency may not be what works in another agency, or even within an agency under a particular statute or particular provision of a statute.
Right.
So, absolutely context matters. But I guess what's interesting is you've got, Lisa Heitserling was the one who was at EPA, who was, sort of most clearly saying this, that there's this chilling effect going on, right? And EPA is the place where you have this really clear, like you've got Scalia saying for the Supreme Court, you're not allowed to consider costs, at least for the National Ambient Air Quality Standards. And yet her sense is there's still this chilling effect. And it'd be interesting to ask her specifically, is it happening with the NACs, and hear what she would say. My sense is that it does, because when you look at the NACs that they put forward, they usually are able to, figure out a way to make the numbers work out. Maybe not every single time,
Right.
but they're usually able to find a way. I tend to, I mean, the notion that these statutory deadlines and the specter of all those big environmental groups out there coming to sue the agencies is somehow like creating an opposite chilling effect, you know, a force in the opposite direction. I'm a little skeptical of, you know, only because there's certainly a lot of empirical work out there from Carrie Cognolisi at Penn and others showing that, you know, the influence of industry on the regulatory process is just vast in comparison to the amount of influence that these, you know, handful of scrappy environmental groups getting their $25 from each of us are able to put forward.
So let's take a look at this sequential process that you described. And I'd like to understand a little bit more of this sort of threshold finding of harm, where you say if there's sort of significant benefits. This is how we think about our accounting or consideration of benefits and costs, as we do this sequential approach. And we first say, is there a threshold of harm? And then we go through and figure out technologically what's feasible to address that harm. What's the kind of information that we would want for that? And what kind of holes would that identify in, say, our current knowledge or the current practice at the agency? Since, as you noted, there's a lot of either unquantified or unmonetized categories of benefits in current practice. You know, it seems to me there may still be some prospect that those holes could apply for this threshold finding. And if that's the case, how do we go about trying to remedy that problem?
I mean, you know, there's a sort of universal call among proponents of cost benefit analysis when they talk about the problem of unquantified benefits. Usually the end of what they say is to say we need to do more research. I mean, great, yeah, I'm all in favor of research. I think I'm a little less sanguine that the research is necessarily going to get us where we would need to be to have the level of quantification that is required to do this direct comparison of society-wide costs versus society-wide benefits. And that has in part to do with what's special about particulate matter. It turns out that particulate matter, because of its chemical nature, I mean, it is literally a particle of a certain size, as opposed to a chemical that has a particular makeup of atoms that we learned about in chemistry and so forth, which means that monitoring for particulate matter is significantly easier than it is for, say, benzene or some other kind of pollutant. And so, you know, there was this whole slew of particulate matter monitoring stations that went up in the 70s, like pretty quickly after the Clean Air Act was passed throughout the country, that gave accurate results of like how much of this particular pollutant is there in various localities. And this produced a wealth of hard data that epidemiologists, you know, like all of that generation of epidemiologists who were trying to get their PhD in the 80s and 90s were able to dive into this great data set and do some real regression analysis and come up with some real results with respect to particulate matter. And the other thing that made particulate matter easier is that it has these really immediate health impacts. Now, it also has some longer term health impacts, like cancer and other stuff, but that's not the stuff we've quantified. What we've quantified is the respiratory impacts that hit you pretty quickly, like your asthma gets worse or you get asthma to begin with, and the cardiovascular impacts, where you drop dead of a heart attack like next year. And those are so much easier to follow for obvious reason in studies, because the study doesn't have to be so long. So that's part of why I'm less sanguine about the notion that, oh, we're going to do more research and we'll get better and better at quantifying all these other pollutants as well. But in terms of like this first step of what I'm calling the sequential cost benefit analysis and what would it involve? Again, depends on context. It's going to be different in different statutory contexts. And certainly, one of the examples I put on my slide, of course, was the Occupational Safety and Health Act and its standards for toxins in the workplace. That's certainly a place where the Supreme Court's famous opinion in the benzene case in 1980 had sort of a kind of chilling effect on that agency, on OSHA. Like they kind of freaked out after that opinion and were like, oh my God, at this threshold finding stage, we have to quantify everything. We can't do anything unless we can quantify it. And I tend to think actually that was a somewhat of an overreaction to Justice Stevens's opinion in that case. But that's a sort of different story, you know. But the notion is that this shows up in lots of places, and you know, throughout the Clean Air Act, the Clean Water Act, we've got some kind of threshold finding. And the idea here is, I'm not against data, like to the extent you have data and you're able to quantify things like the number of people that are going to die of heart attacks and respiratory problems from particulate matter. It's great to use them, but the beauty of not requiring the direct comparison between costs and benefits is that you don't get into that whole monetization business, and you don't absolutely have to have things quantified in order for them to sort of work in the calculus, you know? And so when you have numbers, you can use them, but you use them in their natural units. You talk about number of lives lost instead of, you know, trying to translate everything in dollar terms. You talk about acres of wetlands lost or whatever it is. That's fine. But you know, you do it in the natural units. If you think about a lot of the big, in my view, virtually all of the big controversial aspects of cost benefit analysis, you know, that have caused so much controversy in the literature for, you know, 5 decades now, they really all come down to this monetization business, you know, on some level, the willingness to pay, willingness to accept conundrum, wealth effect, from a wealth effects, the problem of discount rates, all that stuff is happening because you're doing this bizarre thing of trying to sort of shoehorn particular values that don't actually have prices because they're not traded in markets into monetary terms.
So you mentioned near the beginning of the talk the importance to think about the distribution of outcomes and the distribution of impacts, and how this is typically not accounted for in the standard benefit cost analysis. My sense is, and we've had some colleagues here at the Kennedy School have done some work on this in the past, is that, you know, Circular A4 from OMB does talk about the value of distributional analysis, but the practice at agencies is that this gets, we'll be polite and say second fiddle, if it gets done at all. So I'm wondering how in this kind of sequential process, how you would try to incorporate a consideration of the distribution of impacts in that analysis.
Yeah, no, that's right. And again, I think part of the problem is that cost benefit analysis and its vision of this comprehensive rationality that's going to take into account all social costs and benefits at once, and we're going to put everything in this scientific mathematical calculation, it has this tendency to crowd out everything else. And so I would attribute some of this sort of the distributional impacts piece getting second fiddle to that phenomenon. And I actually think that some of these other methods that I had up on several slides that Congress has made use of in many of our existing environmental health and safety statutes really give more room to the kinds of narrative descriptions that need to happen in the context of distributive impacts. You know, and this, if taking this sequential cost benefit analysis with its initial step of a threshold finding of harm from the pollutant is a perfect example, right? Because that step of the analysis would allow for example, the kind of zeroing in on, let's say, a community in Cancer Alley in Louisiana, some of these communities that are suffering all kinds of cumulative impacts from a whole series of industrial facilities that have been sited down there, some of which emit toxic hazardous air pollutants that are almost specific to that particular plant in Cancer Alley. You know, like there's some of these toxic air pollutants that are just emitted in a few places in the country, and we're down there in Louisiana. And so if you look at that pollutant, like through the cost benefit lens, where you're sort of looking at overall social costs and benefits in the country as a whole, that pollutant looks really insignificant if you total up the number of lives you could save by reducing levels of that pollutant. It's like, oh, it's not that significant because it's just some Black and brown people in one community down in Louisiana. But if you've switched to this other way of doing things, where you're no longer trying to look at society as a whole in the United States and putting a dollar value on everything, but you're just saying, what is the harm here? I think that's much more compatible with a kind of zooming in on particular communities, fence line communities and so forth, that really need more attention than they've gotten up to this point.
So we spent some time talking about executive orders from the Reagan administration, from the Clinton administration. We've not talked about executive orders from the Trump administration. And so I'd like to get to this question about deregulation. And it reflects a question we received in the Zoom chat as well. You noted in the Biden presidential memorandum on modernizing regulatory review an interest in ensuring that we avoid harmful deregulatory efforts. And deregulatory efforts can take a number of different flavors. I've talked to regulators before where some of it is in a sense kind of mechanical or good housekeeping. And their example is this, for example, the Department of Transportation, they review every regulation at least once over 10 years to just see if the laws change. That there's some cases where they actually had rules on the books that actually no longer had an underlying statutory authority. There's some where, as technology has evolved, say on just reporting, we think about the technology of reporting by regulated entities to go from paper, which is not all that useful now, to electronic reporting can both save costs and provide that information in a more useful format for the regulator. So we have some kinds of deregulation or revisions to regulation that are probably not, they're probably not what motivated the Trump administration. They're probably not what we would find all that controversial. But there is a question though, is sort of what at the end of the day do we think is kind of a harmful deregulatory effort? How do we identify what may be harmful as a deregulatory effort? And what are your sort of thoughts on any lessons that can be drawn from what was the regulatory cost budget and one in, two out approach in the Trump administration under their executive orders, which if I recall correctly when reading the language about which executive orders are now struck by new Biden executive orders, I don't think those are actually in force anymore. But I'd like to sort of hear your thoughts about how we think about deregulation and what are sort of, you know, benign, good housekeeping deregulatory efforts. What may be, you know, the world's really fundamentally changed. This may make some sense, certainly on reporting that may make sense, but there may be other contexts where that may start to make sense. And what may be truly like harmful? How would we go about identifying those that are harmful deregulatory efforts? How would we help a regulator make sure they don't go down that route?
Yeah, I mean, I think you're right to sort of divide deregulatory efforts into those categories. I think there's a lot to that. I think you're also absolutely right that you know, the kind of housekeeping deregulatory measures is not something that I don't think either side is particularly concerned about, right? I don't think anybody's going to argue that, of course, we should update the books and make sure it reflects sort of the current state of the law. That's fine, and that's not controversial. And I think, you know, you honed in on the word that the Biden team carefully put in that executive order, which was harmful deregulatory effects. What are the harms? I think it's the same harms that we look at in a cost benefit analysis or in one of my alternatives, right? It's like more people are going to die from air pollution or the climate crisis is going to be exacerbated. It's all of those harms that these regulations are put in place to try to forestall or to reduce, right? I mean, I think in some ways, the harms that you're looking at, in some ways it goes back to what I'm saying about making primary the agency's statutory missions, right? It's because that's where we look to see what are the harms that Congress had in mind when it put this statute in place and delegated authority to this particular agency to implement that statute. Right?
Can I ask something specific on that? Sorry, go ahead.
No. I was going to talk about the 2-for-1, but let's talk about this first.
No, let's do 2-for-1 because it's an important question, and given your expertise in environmental law, and we've already talked some about the climate crisis, how do we actually use the Clean Air Act to deal with climate change? Because there are some who would argue when we think about these provisions that are in the statute of the Clean Air Act, very few of them, well, many of them were written before we even had a decent feeling, I think, among at least those in Congress writing the law about climate change. When we think back to the 70 amendments and the 77 amendments, I mean, it was just dawning on them when they wrote the 90 amendments. And of course, this is part of the question about as we go forward and whether it's some future clean power plan under the Clean Air Act or other regulatory approaches that people have talked about. Do you consider CO2 a NAAQS, a criteria pollutant under the NAAQS? Do you think about using some provisions of the Clean Air Act we haven't used before? I'm kind of curious your thoughts on how, when we face sort of new environmental threats or new relative to when many of these statutes were written, how do we make sure that we're actually reflecting what we think is sort of Congress's objectives that they laid out in that statute? So I'm curious in what you have to say. That I'm also curious about the 2-for-1 as well.
Yeah. Well, let's take the climate thing first. I mean, there's a lot of pieces to that. I mean, the first thing is I really hope that the Biden administration doesn't have to rely primarily on the Clean Air Act in the way that Obama ended up doing by the end of his second term. I really hope that, for example, that the Biden administration is able to do a lot with this infrastructure bill that they say is sort of next on the list now. And to that point, one of the things that I have found most refreshing and optimistic about the approach that Biden has taken so far is this all of government approach that is reflected in almost everything they say. Almost all of the executive orders coming out make really clear that he is not just making climate a priority, but it's front and center in everything and everything that every agency is doing. Like, he recognizes that it goes to absolutely the mission of every single department and agency of government. And that's how it needs to be, right? And it's good that it's not sort of pigeonholing it or ghettoizing it as this is just EPA's problem, right? And it takes some of the pressure off of EPA and says, no, there's a lot of other stuff that's got to happen in other departments here. So that's one thing. But in terms of the Clean Air Act, I think that the DC Circuit's opinion that came out literally the day before Biden was inaugurated, striking down the ACE rule, the Trump administration's power plant rule, and in so doing, basically endorsing the fundamental approach that the Obama administration had taken in its Clean Power Plan, regulating greenhouse gas emissions from power plants. That their reasoning made a lot of sense to me. The Clean Air Act was passed in 1970 before most people were talking about climate change. But you know what? Congress does this thing, like they get that the world is going to change in the coming decades. And when they write legislation, they often use broad language precisely in order to try to capture new developments that may happen, both in terms of scientific understandings and in the way that sort of the world develops. And that's what they did in the Clean Air Act. Now, that's not to say there aren't awkwardnesses in the fit, which is part of why I really hope that Biden can use a lot of other means to do it. But that being said, I think, and back when the Obama EPA first started doing this, they had choices to make. As you say, they could have tried to go down the NAAQS route and said, we're going to have a national ambient air quality standard for CO2, for example. It certainly fits within the endangerment finding you would have to make under the statute. That would be no problem. The fit is awkward, though, for a whole bunch of reasons. I think they made the right judgment call by going under Section 111. I think that made sense. I think it's really doable. But I think, again, it's one tool in what needs to be a much broader arsenal, even within EPA regulation, right? And this was part of, I think, the Obama EPA strategy as well, is that they can use other regulations under the Clean Air Act that go after conventional pollutants to also put pressure on the coal plants to close, because that's what needs to happen. And some of that pressure came from, for example, the Mercury Rule during the Obama administration, and other rules that are aimed at the co-pollutants that go along with climate. So that's also a big important part of the strategy there.
Of course, the Mercury Rule is an interesting example where almost all of the very sizable monetized benefits are the fine PM co-benefits that you referenced earlier.
Yeah. Well, that's right, because that's true of all the hazardous air pollutant regulations, of which Mercury is one. In fact, the Mercury Rule is the only one where they have managed to monetize a tiny, tiny sliver of the health impacts associated with the actual hazardous air pollutant, that is mercury. Although that's not the only one that regulation regulates. On the 2-for-1, I'll just say briefly, you'll notice I didn't mention Trump much in this talk. I don't really see the Trump administration as all that relevant in that. I had the one picture of him cutting the red tape, which I like that picture. But I don't see it as that relevant. I see this cost benefit debate as more of a trajectory that began, back with Reagan and sort of goes through Obama. And then this crazy things happen, and it happens in the next 4 years, and then now we're sort of back to. The 2-for-1 order, I mean, it's a funny thing because it shows the extent to which the right wing itself and the really sort of hard edge of the right has itself backed away from cost benefit analysis. And Michael Livermore, I think, was talking about this a little bit in your seminar a couple of weeks ago. I actually attribute some of that, and I wrote an article about this in the American Prospect a few years ago. I attribute some of that actually to the whole particulate matter thing that we were talking about. Because remember how I told you about 94% of the total benefits that EPA is able to monetize, all are attributable to particulate matter? Well, that has not escaped the notice of the right-wing think tanks.
Right.
In fact, in some ways, they were the first ones to notice, and you can find some white papers going back a good decade now, maybe a little more, where they actually point that out. And for that reason, they have sort of launched a campaign against particulate matter that involves the 2-for-1 approach, which is a departure from cost-benefit analysis,
right.
But it also involves this whole fight against co-benefits,
right.
And it involves the fact that some on the right have begun to literally question the very solid epidemiological science behind the fact that particulate matter causes health impacts, kind of taking a playbook out of the climate change denial movement to try to just say, oh, no, the science is wrong or something. So it's interesting because
I think that I find their cynical use of the term transparency to justify discarding all of this epidemiological literature. So if the raw data cannot be put into the public domain, which they know well what they're doing there, because of course the original agreements to get those individuals into those cohort studies were going to ensure the confidentiality of those data. We can't make put those in the public domain, and it's something that is kind of standard practice, even though we've had many replications. Like when we think about sort of what may constitute good science is that you undertake some interesting research, you show something, and people are like, wow, that's a big deal. Can we replicate it? And we have. Yeah. We've done this a number of times, but you're right. We had back in 2017, in the spring of 2017, Ricky Rivez visit the seminar. Mm-hmm. And he actually was highlighting this as something that would be a target for the Trump administration. And I think it's clear over some of the things they attempted to do over the next few years, we're trying to remove from consideration and benefit cost analysis, one way or another, fine particulate matter benefits.
I'm glad you mentioned the science transparency rule, because that's a big part of that. And I will also say that since you mentioned Ricky Rivez, he and a co-author at the Institute for Policy Integrity did a great article that talks about the particulate matter thing and sort of debunks the whole co-benefits argument. They really did.
Right. So unfortunately, it's 1 o'clock. I'd like to continue this conversation, but we need to wrap up now. We're going to keep, as I remind everybody, we're going to keep a Philly theme. because we'll meet again in 2 weeks with Kerry Calanese of the University of Pennsylvania School of Law. Thursday, March 25th at 12 o'clock, he will present Algorithm versus Algorithm, a framework for governmental use of machine learning. So if you're into AI, you're into machine learning, this is a seminar for you. And finally, please join me in thanking Professor Sinden for her presentation and discussion today. Thank you so much, Amy.
Thanks so much. Thanks, Joe.
And for everyone else, I hope you enjoy the rest of your day. Take care.